Great. Welcome everybody to this session, a Zoom session of the Kansas Court of Appeals. I'm Karen Arnold Berger. I will be presiding over the proceeding today, which basically means I'll just be keeping time for you all. Joining me is Judge Tom Malone, who hails from the district bench in Wichita before he came to our court. And also joining me today is Lori Bolton Fleming, the newest member of the Court of Appeals, who hails from Crawford County, Pittsburgh, Kansas, as a district judge. So we're looking forward to your arguments today. If you would each just state your appearance for the record, I will call officially case number 127613 in the matter of the marriage of Barbara Jean Bates and David Allen Bates.
May it please the court, David Bates appears through counsel Richard W. Martin. Mr. Bates is the appellant.
Right. Okay. Thank you. And did you wish to reserve any time for rebuttal, Mr. Martin?
Yes, Your Honor, please.
And how much time? 15 minutes total. So
5 minutes.
So yeah. 10 and 5, and I'll let you know when you're getting close. So if you want to continue, you can. But okay.
Thank you, Your Honor.
And for the appellee?
May it please the court, Stacey Stranthan appears on behalf of the appellee, Barbara Saunders. She's formerly known as Barbara Bates.
Okay. All right. We are ready to proceed. Mr. Martin, if you want to go ahead whenever you're ready.
Thank you, Your Honor. While this case was being heard in the district court, and I'm talking about Mr. Bates' post-judgment motion to declare that this judgment is dormant and non-revivable, the Kansas Supreme Court came out with on the same day in June of 2023, two opinions that I think clarified the issue that was before the district court in this case. And admittedly, I was a little confused about the landscape of the case law on this issue until those opinions came out. So Mr. Bates' motion relied primarily on the marriage of Larimore that essentially gave, once the judgment, the divorce decree judgment was final, it became dormant 5 years, talking about division of most retirement accounts. The judgment became dormant 5 years after the divorce decree was entered, and the judgment became final, and it became non-revivable another 2 years after that. The appellee in this case countered with the marriage of Strom, which held that when it comes to a military retirement, each payment due becomes its own separate judgment, subject to the dormancy period at that time. And that is what the district court here in this case relied upon primarily in finding that those judgments that were not, or I should say within the last 7 years, were not dormant and non-revivable, and that Mr. Bates' retirement payments would be payable going forward. The Kansas Supreme Court in the cases of Holliday and Schaefer, in Holliday, the Supreme Court set forth a rule that when it comes to military retirement division pursuant to a divorce, that the dormancy period is stayed because, as a practical matter, no execution can issue until those retirement benefits become due and payable. So that dormancy period is told, notwithstanding that it was a final judgment at the time of the divorce decree. In the companion case, came out same day, marriage of Schaefer, was kind of decided on different grounds. There, the wife, the would-be recipient of the military retirement benefits sought for clarification from the district court about the particulars of the division in order to affect it. And so the Kansas Supreme Court, Schaefer said, well, that's just clarification. That's not a modification. But tellingly, for the purpose of this case, the Schaefer court said that although the matter wasn't briefed, the court's holding in Holiday suggests that this case is resolved altogether and remanded the case to the district court to make findings consistent with that. And that strongly suggests that when it comes to military pay, that the Holiday holding applies to military benefits, notwithstanding that the Holiday court was dealing with Capers benefits, but same thing. During the pendency of, or until those benefits become due and payable at retirement, there's no legal execution as a practical matter that can enforce those orders. So here we have military benefit, I say under Holiday and Schaefer, that rule applies, not the Strom rule. It says that a payment due is its own separate judgment. So
let me stop you. Let me stop you and ask you a question.
yes.
So you're correct. Holiday is a Capers benefit case. But Holiday, my reading of Holiday was they were really focusing on the tolling. So, you know, is the time tolled until these payments start becoming payable because someone's retired? Strom is a military benefit case that says each of these payments is a separate judgment. So why can't Strom and Holiday be read together? Where's the conflict in that?
Well, I think that Holiday starts from the premise that the judgment becomes final at the time of the decree. Whereas, I'm sorry, that's Holiday. Whereas Strom says, no, each payment due is his own separate judgment. So I think they're in direct conflict.
Well, doesn't Holiday say the dormancy period gets tolled until the husband's benefits became payable to him?
Yes.
Okay.
After, that's kind of the second prong of the analysis. First prong is this a final judgment? Yeah, it's a final judgment at the time of the decree is what Holiday said. And I think that's in direct conflict with Strom. Now, on the facts of this case, it's undisputed that Mr. Bates began receiving his military retirement pay in September of 2008. So that's the point at which execution could issue for Ms. Bates on that account. There was no execution that issued. However, it's also undisputed that Mr. Bates began paying directly some amount of money, however inartfully calculated, in January of 2018. And so that's approximately 10 years after the dormancy period began or ceased being tolled. And so even at that point, the judgment was dormant and non-revivable because it was 10 years later or thereabouts. So at some point, Mr. Bates began or ceased making those payments directly and filed his motion here in the District Court of Johnson County to declare that the judgment was dormant and non-revivable and asking for it to be released of record.
I'm going to stop you again. Let me stop you again real quick. So let's go back and talk about what happens in 2018. So this settlement agreement, the intent was he would be paying her these military payments when he retired. And then as I understand it, he discovers the military has this 10 and 10 rule. You're not married long enough. You can't receive the direct military payments. So he says to her instead, I'm just going to make direct payments. So I'm trying to figure out, is that a modification of the settlement agreement? And does the fact that the nature of the payment changes from a military payment to some sort of voluntary payment, how does that all impact the analysis under Strom and Holiday and Schaefer?
Well, the way I'm looking at that is Mr. Bates, either because of a misapprehension of law or as a gift, was making those payments directly, but he wasn't obliged to do so, and he's not obliged to do so now. Now, the party settlement agreement, the other argument we made in the district court was that's effectively a modification of the party settlement agreement by judicial action. And so just because the party settlement agreement provides only one way of payment, and that is by qualified court order. And it says that the district court reserves jurisdiction only for the purpose of amending the order and in order to establish or maintain the order as a proper qualifying court order. Doesn't say anything about direct payments. And
Well,
so,
let me stop you. So section 5.8 of that agreement says if at some later date a modification is agreed to by the parties, it shall be reduced to writing, signed, acknowledged before it becomes effective. And so here there's some sort of communication between the parties, and he starts making these payments. So you don't think that the parties modified this agreement to change, the source of the payment?
not by the method prescribed in the party settlement agreement. Anything reduced to writing is certainly not part of the record. And I can tell you, I'm not aware of any writing that's been signed by the parties modifying their settlement agreement. So under the authority of Marriage of Cotter, I have a cite for you, but I believe that opinion issued in June 2011 was involved in that case. The party settlement agreement provided that wife would make timely mortgage payments on the party's ranch. That was $800,000 mortgage note at the time. She ceased doing that, and so husband moved to sell in the district court, and this court held that that would be a modification of the party settlement agreement because there was no provision for the sale of that property, notwithstanding that wife was no longer making those payments. So at least for a time, husband was stuck with his name on that mortgage note. So I would say likewise that judicially saying that that's modification is an impermissible modification of the party settlement.
Okay, you're at your time limit. We've asked a lot of questions. I'll give you like a minute to sum up this part if you want, and you'll still have your 5 minutes of rebuttal.
I appreciate that, Your Honor. I've said all I needed to say.
Okay. All right. Appellee, Ms. Stranathan. You're muted.
Sorry about that. May it please the court. We believe that the judgment at the trial court level should be affirmed because that Judge Haber applied the correct precedent that should be applied to this case, which was Strom. And our position is that the appellant is trying to stick a square peg into a round hole by trying to fit the facts of this case into any other case, whether it be Larimore or Holiday or Schaefer. And it just doesn't fit any of those holes. And there is a perfectly good square hole waiting, which is Strom, which fits this fact pattern that we have here exactly. It's funny if you read Strom and you look at the facts of this case, you could almost one for one replace the parties and it would be the exact same fact pattern. I've never seen a fact pattern so closely mirror the other one. In both, they had a property settlement agreement that they intended to divide the military retirement pay, and they thought that the military could do it. And in both cases, they found out that they were thwarted because of this 10-10 rule, because the marriage was not quite 10 years. They were married over 10 years, but the same 10 years that he was in the military has to overlap. And so they just had a mistake when they came to the agreement. They thought the military would be able to divide it, and that turned out to be impossible. And however, in the original property settlement agreement, it has a statement in there which states that it charges the parties to take whatever steps may be necessary in order to implement the terms of this agreement and effectuate a transfer of the above described retirement benefits to the benefit of the wife. So they agree in the property settlement agreement that if this is the intent, she's supposed to get these benefits, and the parties will do whatever it takes to see to it that that happens. And Judge Haber actually wrote a very long decision in this case, and I think it was very well reasoned and thought out. But one of the things that he discussed kind of at length, and I would point to and say that I fully agree with, is that he said that the quadro, that what was discussed in the property settlement agreement, but the quadro was simply a procedural device used to effectuate the transfer that the parties intended. It wasn't a substantive part of the agreement. The substantive part of the agreement is that they would share their retirement. They contracted for that. And the procedural device, which is the quadro, it failed. It was impossible because of the 1010 rule, but that didn't alleviate the appellant from his obligation to, share his retirement pay with his wife as they intended when they signed the agreement. And Judge Haber said that the quadro was not a substantive term. It was only a specified means of achieving what the parties had agreed on. And so he applied Strom, which I fully believe is the perfect precedent here. And I don't think it's in conflict with either of the recent Supreme Court cases, Holliday or Schaefer. Holliday or Schaefer could have specifically said this overturns Strom. Now Strom doesn't apply. Neither one of those cases did that. As your honors pointed out, those cases were talking about a tolling provision, and they were talking about they just weren't on point exactly with what's going on here. Counsel talked about how the appellant began getting his retirement in 2008. And in early 2008, the facts state that he told my client that he wasn't going to get retirement for a while, and he'd let her know when he did. And sadly, she trusted that. And he began later that same year getting his retirement and didn't tell her and didn't start making payments to her. And I believe at the end of 2017, almost 10 years later, she asked him, like, are you not getting retirement? What's going on? And then he told her that he was getting it, and he would start making those payments to her as agreed. And he did. He began in January 2008 making those payments. With regard to the tolling, I think there could be an issue of whether the judgment was told until 2008 when he began receiving it, or would it really be told until 2018 if he was committing what I consider to be a fraud and not telling her about it, and she didn't become aware that he was receiving his retirement until into 2017, beginning of 2018, when he finally started paying her. She lost 10 years of what she should have gotten, in my opinion. She has already lost those 10 years, and which is sad for her. But if we're talking about tolling, I would almost say that the tolling shouldn't even begin until the start of the period where she became aware was 2018 that he's getting it, not back in 2008, and certainly not at the time that the judgment was final is not when it began. So we would just argue that Strom does fit here, and that because the method that they chose to divide it, the quadro, was not available to them, and because there was no way that she could have gotten a lump sum payment up front, because the way that it was worded is you get a set amount based on this formula, which also looks at cost of living and stuff like that, which changes frequently. And she is only entitled to a benefit on a specific month, say December 1st. You have to look back and say, okay, what's the formula today? And are both parties alive? Because if one of them's dead, she doesn't get it. So you can't just in the future say, well, this judgment is worth this much money, because we don't know how long the parties are going to live and when it's going to end. And because those factors had to be looked at and examined, the Strom court said that it created a situation where each month that passes creates a new judgment, because you have to look at those facts and say, yes, okay, they're both alive, here's the amount, and a new judgment is set each month, and that's how it should be handled. And
I'd
so
like to have you pause for just a second. So your opposing counsel is arguing that because in Holiday, the court found the 2009 divorce decree to be the judgment, in effect, that overrules Strom that says every single payment is the judgment. So can you respond to that?
yes, because I believe in Holiday, the court themselves distinguished Larimore, which is Larimore's the one that talked about judgments becoming dormant and unrevivable. And let me see here. Sure, I pull it up here. And in Holiday, they distinguished Larimore and said that a quadro in the Larimore case, the reason it went dormant is the quadro was available to the lady and she didn't execute it. And in Holiday, the wife had no legal process available to her until the husband started getting benefits. She couldn't file a quadro or do anything, so that's why it gets into all of the tolling. But it talks about Larimore, which is kind of the part about dormancy, and saying that in Larimore, there was access to a quadro that could have been done and wasn't. But in Strom, a quadro could never be done. And so it's not like she failed to execute or failed to do something. A quadro was impossible. And so that's why in Strom, they went to the monthly payments being the proper way to handle that. Do you have any other questions?
Thank you.
I have a question about the fee issue.
Yes.
The district judge awarded fees, and as I understand, did not weigh one party's needs against the other party's ability to pay. That's what the appellant is arguing, and I think you pointed out that this issue may not be preserved. But other than the preservation problem, do you have any substantive response to that argument?
Generally, attorney's fees are at the trial court's discretion, and the appellate court will usually assume that the trial court found all of the facts that they needed to award the attorney's fees that were at issue. And and I do think that the primary thing here is that if appellant felt that the facts weren't there, or that the facts weren't laid out specifically in the judgment, then he should have done a motion to amend and ask for the factual basis behind the award for attorney's fees. And because he didn't ask for that, then I think it should stand and be assumed that the trial court found the facts necessary to award those fees.
Well, there was a motion for reconsideration, but he didn't bring up the fees in that. Is that
True.
so? I think you argued waiver there. Is that right?
I believe so, Your Honor.
All right. Thank you.
And that is it for me, Your Honor, unless you have any other questions.
Any other questions from the panel? Okay, thank you. Mr. Martin, you have your 5 minutes of rebuttal. You're on mute.
Thank you.
We just
All right.
need a little button to push that says you're
I think after hearing arguments, this is kind of boiling down to when was the judgment final, and it's there in Holiday's syllabus 1, judgment's final when the parties' rights are determined, and that's the decree of divorce. And so that's when the clock would start, except for we have this tolling period. that ended on September 1st of 2008. And so that's when the dormancy clock started. I find it hard to believe that Ms. Bates didn't know when her husband of more than 10 years was going to be eligible for retirement or be in fact retired. And if she wasn't sure, she could.
I'm sorry, would you say that again? You find it hard to believe what?
Yeah, Miss Stranahan is advancing some kind of fraud argument to extend the tolling, and I think there's no legal authority for that under the dormancy statute. But for the sake of argument, I find it hard to believe that Ms. Bates didn't know when her husband of many years was eligible to receive retirement benefits or was in fact retired himself. My understanding is the parties kept contact throughout that time anyway. So I think we're just on the operational law.
So you're saying she had a legal duty to investigate when he started receiving his retirement?
I'm saying it's irrelevant.
The fact that he said he wasn't receiving it.
Yeah, I'm saying it's irrelevant. It's that it's just by operational law, the judgment's dormant. And but for the sake of argument, I do find it hard to believe that she didn't know when her husband retired. And I think that's kind of thrown out as an inference by her attorney here. And I'm just kind of rebutting that inference a little bit. I think it strains credulity. I appreciate Judge Malone bringing up attorney's fees. My impression was the district court was just kind of irritated, maybe with me, maybe with my client, I'm not sure, but he just thought that this shouldn't have been contested at all. He thought it was so clear. I disagree. I don't think it's so clear. And so whether it's a 211 analysis, which the court did not conduct under Vondracek or Wood v. Grow, or a financial needs analysis, the district court did neither, that the attorney fee award was improper and should be overturned as well. That's all I have.
Okay, any other questions from the panel? Okay, thank you both very much. We will take this matter under advisement and issue an opinion as quickly as possible. We appreciate your timely appearance today and the good briefing that you've done in this case. So thank you very much. We will get a decision out shortly.
Thank you, Your Honors.
Thank you all.